For those of us who are working folks out there, we all hope when we start a new job that our boss is going to take care of us. And if you are a boss, you probably hope that your employees are going to do their work, they're going to show up on time. But that may not always be the case. There are disagreements that arise between employers and employees. And here to talk about some ways that we might be able to handle some of those issues without escalating them too far is Bill Morgan from Murphy Desmond. Hey, Bill, how are you?
Doing fine, thank you. Thank you for having me. It's a pleasure to be here.
Absolutely. So we're talking about employment law today. Let's start with the basics. What is employment law? What does that mean?
Well, in my experience, employment law encompasses a broad range of things, including statutes, administrative codes, municipal ordinances. It also includes any case law, which impacts the relationship between employers and employees. When you think of employment law, think of issues such as the minimum wage law, labor laws, laws which protect against discrimination, harassment. It also includes such things as the Family Medical Leave Act and other benefit programs, as well as regulations involving workplace safety, OSHA or regulations. As for who employment laws are intended to protect, ideally they should protect both employers and employees depending on the situation.
So what would you say are the biggest issues or the most common issues you see coming through your practice?
Well, on the employer side, I most often see matters involving the interpretation of the ADA or the FMLA and general discrimination issues. We routinely field questions from employers regarding employee classifications, whether they are exempt under the FLSA or whether they really should be classified as an independent contractor, not an employer. We also help employers with immigration matters, job postings, and the like. On the employee side, what I most often see are questions about pay practices, overtime issues, discrimination issues under the FMLA or the ADA. I work with both employers and employees, so I see a wide range of legal matters.
And we've all heard the term or the phrase that an ounce of prevention is worth a pound of cure. Let's switch gears here and talk about that when it comes to the employer side of things. What are some of the things that the issues that you talk about with some of your clients from a proactive standpoint? What do you encourage them to be proactive about specifically?
Well, first of all, it depends on the size of the employer and what business sector they're in. For example, if they are in a business sector which relies on repeat clients, or they have a business with a unique client base, the first thing I would look for is whether or not they have a valid enforceable employment contract for key employees, which includes non-disclosure provisions or non-compete clauses. For a larger employer, perhaps 25 employees or more, I would look to see if they've adopted an employee handbook or written workplace policies. Such things can establish clear communication with employees, and they're really a good way to avoid future problems.
Absolutely. And when we hear the term employment law, a lot of times people think, well, that just applies to people who are employers, who are the bosses and so forth. But it really should apply as well to employees. What should employees know about employment law? And let's say if they have a potential case against their employer.
Justin, that's absolutely correct. First and foremost, they need to know that they might only have a very short time frame to challenge an adverse employment action or administrative decision if they're already in a case. They need to take action quickly, or significant rights might be affected. For example, discrimination issues may only be challenged for 180 days. Secondly, it's really important to talk to a lawyer before you quit. Depending on the matter, the employer may need to be given an opportunity to fix the problem. If the employer is not given that opportunity, the employee may have lost their opportunity to file a claim.
So if you're having an issue with your employer and you think you may have a case against him, don't quit until you've talked to a lawyer first, is what you're saying.
Absolutely not. Happens all too often.
Yeah. So what exactly can a lawyer do to help if an employer or employee may have a potential problem or a lawsuit that's right around the corner?
Sure. Well, for an employer, if it's a termination issue, they should consult with a lawyer before they take action against the employee. If they don't, they may not be adequately protected if the employee later files a lawsuit. On the other hand, if you're just hiring an employee, it's a good idea to consult with a lawyer. What you've been previously advised or told may no longer be legal. There are changes in the law all the time. A good lawyer is more than just a legal advisor. They are also an important part of the business. For the employee, on the other hand, if they're just starting a job and are being asked to sign an employment contract, we can tell them if that contract is enforceable and negotiate any changes if necessary. On the flip side, if something's happened at work, it's important to seek advice right away just to see if they have anything. Unfortunately, as we discussed earlier, I often see employees who, on the advice of family and friends, have quit only to find out that now they don't have a case and they now don't have a job. If you have any of these issues, reach out to us. We handle these things all the time.
Bill Morgan from Murphy Desmond, thank you so much for taking time out of your day. We really appreciate it.
Pleasure being here. Have a good day.
Don't go away, there's more after the break. Stick around.